Welcome back to MAYANK LAWHOLIC. In this video, we will be making the MCQs of Indian Contract Act, and this is the part 9 of the series of the Indian Contract Act. So let's get started from question number 201. When the consent to the contract is caused by coercion, the contract is voidable, void, valid, illegal. Correct answer here is option A, that is voidable. Question number 202. Under Indian Contract Act, an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or other parties, is option A, an illegal agreement, option B, a void agreement, option C, a valid agreement, and option D, a voidable contract. Here correct answer is in question number 2 is option D, that is avoidable contract. Question number 203. A agrees to sell his scooter worth rupees 10,000 to B for rupees 5,000 only as a consent was obtained by coercion. Here the agreement is void, valid, voidable, unlawful. Correct answer is option C, that is voidable. Question number 204. X enters into a contract with Y for which Y is guilty by fraud. X can set aside a contract but cannot recover the damages. Only recover damages. Set aside a contract, can recover damages also, and option D, none of the above. Correct answer is option C, that is set aside a contract and can recover damages also. Question number 205. A enters into a contract with B. In this, B is guilty of fraud. A can now rescind the contract but cannot get compensation. B get compensation only, rescind the contract and get compensation, none of the above. Correct answer here is option C, rescind the contract and get compensation. Question number 206. A intending to deceive B falsely represent that 500 tons of indigo are made annually at A's factory and thereby induces B to buy the factory. The contract is void, voidable at B's option, voidable at A's option, and unlawful. Correct answer is option B, that is voidable at B's option. Question number 207. Match list first and list second and select the correct answer by using the codes given below. So here we have to match the list first and list second. So undue influence is related to fiduciary relation. Fraud is related to contracts, Uberima fights. Misrepresentation is related to positive assertion not warranted by the information of the person making it. And the last one, coercion is related to unlawfully detaining of property. So by going through these matches, the correct code here will be in question number 207 will be option A. Question number 208. When both the parties to the agreement are at mistake regarding facts, the agreement will be enforceable, option A, B, be voidable, option C, not be void, and option D, be void. Correct answer here is option D, that is be void. Question number 209. Non-est factum means option A, document executed in ignorance, option B, document executed under coercion, option C, document executed under undue influence, and option D, document executed outside India. Here correct answer is option A, that is document executed in ignorance. Question number 210. The defense of non-est factum is available to the contracting party who has committed mistake as to nature of contract, identity of the other contracting party, quality of the promise made by the other contracting party, and quality of the subject matter of the contract. Here in question number 210, correct answer is option A, that is nature of contract. Question number 211. Consider the following statements. Consent obtained by mistake renders an agreement void if it is option statement first, regarding value of the subject matter of the contract. Second, a mistake of fact by both parties of the contract. Third, a mistake of law in force in India. Fourth, a mistake of foreign law by one party to the contract. Here in question number 211, correct answer is option B, that is second only. The second statement here is correct, that is a mistake of fact by both the parties to the contract. Question number 212. The nature of an agreement made under the provisions of section 20 of the Indian Contract Act would be valid, invalid, void, voidable. Correct answer here is option C, that is void. Question number 213. A agrees to sell to B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out that before the day of the bargain, The ship conveying the cargo had been cast away and the goods lost. Neither party was aware of these facts. The agreement is voidable at the option of A, voidable at the option of B, void, valid. Here in question number 213, correct answer is option C, that is void. Question number 214. In order to render a contract void on the ground of mistake, the mistake may be of law, of fixed fact and law, of fact and not a law, and option D, none of the above. Correct answer here is option C, that is of fact and not a law. Question number 215. What is the position of a contract when it is being caused by mistake of law? Option A, voidable, option B, not voidable, option C, void, and option D, illegal. Correct answer here is option B, that is not voidable. Question number 216. Two parties entered into a contract. They later realized that the law as they understood as applicable was not in force in India. This makes their contract illegal, void, voidable, none of these. Correct answer here is option B, that is void. Question number 217. Two parties entered into a contract. They later realized that there was a mistake in their understanding of the law as applicable in India. This makes their contract non-est, void, voidable, none of these. Correct answer here is option D, none of these. Question number 218. An agreement made to sell a cargo which was not in existence at the time of the contract is voidable at the option of the either party, a valid agreement, a void agreement, and unenforceable agreement. Here correct answer is option C, that is a void agreement. Question number 219. A and B makes a contract grounded on the erroneous belief that a particular debt is barred by the Indian law of limitation. Option A, the contract is voidable. Option B, the contract is not voidable. Option C, the contract is void. And option D, the contract is void because both parties under a mistake. Correct answer here is option B, that is the contract is not voidable. Question number 220. A contract caused by a mistake of law not in force in India is void, is voidable, has the same effect as though it is caused by the mistake of fact, and option D, none of the above. Correct answer here is option C, has the same effect as though it was caused by the mistake of fact. Question number 221. A agrees to sell a horse worth rupees 5,000 of rupees 1,000 to B. A's consent to the agreement was freely given. The agreement is a contract, not a contract, for inadequacy of consideration, not enforceable, against the provision of the Contract Act. Correct answer here is option A, that is a contract. Question number 222. X, a Delhi merchant, and a native of Delhi entered into a contract with Bai, a Jabalpur merchant, for the purchase of 50 quintals of sitafal. In Delhi, sitafal is a vegetable, while in Jabalpur it is a fruit. Option A, the terms of contract are to be interpreted as per the meaning of the proposer. B, the terms of the contract have to be interpreted as per the meaning understood by the acceptor. C, the contract is void on account of the mutual mistake as to the meaning of sitafal. No concluded contract has come into being as there was no meeting of minds. Here in question number 222, correct answer is option C. The contract is void on the account of mutual mistake as to the meaning of sitafal. Question number 223. An A agrees to pay B rupees 1,000 if B will marry to A's daughter C. C was dead at the time of the agreement. The agreement is invalid, voidable, void, valid. Correct answer is option C, that is void. Question number 224. A agrees to buy from B a certain horse. It turns out that the horse was dead at the time of the bargaining, though neither party was aware of the fact. The agreement is void. This agreement valid for compensation, either A or B, none of these. Correct answer here is option A. The agreement is void. Question number 225. A agrees to sell to B the goods which are on their way to Chennai from Oman by a ship. But before the agreement between the parties, the ship had sunk and the goods to be sold to B were lost. Neither party is aware of this happening. The agreement is void, voidable, valid, enforceable. Correct answer here is option A, that is void.